and that is that a lot of the work that the immigration courts are doing relates to asylum claims. I mean, that's one of the ways that illegal immigrants, one of the chief ways illegal immigrants try to avoid being deported. And are there changes in asylum law that could address, in other words, similar to, say, changes of the border would reduce the demand on the immigration courts? Are there changes in immigration law that would do something similar?
Look, these two, our current judge and former judge, need to answer that. But what I will point out is that the last numbers I saw estimated that upwards of 80 to 90% of the asylum claims are fraudulent claims. So there's very clearly a problem there.
Either one.
Go ahead, Larry. You can go first.
Well, our association does not make recommendations as to the law. We want to efficiently and fairly enforce whatever the law there is. So I would only say that it might be nice to clarify some things. For example, the law on aggravated felony right now is insane. I mean, there is no theft in Virginia anymore, for example, because the Fourth Circuit found that the Virginia theft statute includes fraud as well, so therefore it can't be theft, and therefore it can never be an aggravated felony. That doesn't make any sense, especially when it's different. I mean, we don't really care what the law is. We just want it to be enforceable, we want it to make sense, and we want it to be uniform.
And I think that that's a very important point that goes directly to your question, and that actually sort of aggravated the increase in credible fear claims we saw along the border, as well as unaccompanied alien minors and families. The law just isn't very clear on, I'm afraid of the gangs. If you're afraid of the gangs, are you a member of a particular social group eligible for asylum, or aren't you? If you are the victim of domestic violence in your home country, are you an individual who is a member of a particular social group, or aren't you? And unfortunately, the law on this is the dog's breakfast. It's time for the Attorney General to step in and issue by certification bright line rules for judges to follow in these cases. We need to be clear about what being a member of a particular social group is. And just by way of explanation, in order to receive asylum, you have to show a well-founded fear of persecution on account of your race, religion, nationality, membership in a particular social group, or political opinion. 4 of those are very clear. I'm a Christian or I'm not. I'm Jewish or I'm not. But unfortunately, membership in a particular social group has become a catch-all that it was never meant to be. And so consequently, numerous claims are made that have to be heard all the way to the end, that at the end of the day are never going to be successful. It's crucial for that reason the Attorney General issue guidelines on certification. It's also crucial that the Department of Justice argue these cases vigorously before the federal circuit courts. I think that part of the problem that we saw in the last administration is that, and I don't ever want to accuse another attorney of not vigorously litigating, but there were cases that probably could have been argued a little bit harder. There were arguments that could have been made in defense of certain decisions that simply weren't. I expect Attorney General Sessions is going to vigorously litigate cases in order to provide more bright line rules so that judges like Judge Burman don't have to issue a decision that then goes up on appeal, that then goes up on another appeal, that then possibly gets certiorari from the Supreme Court. So I think that brighter line rules will be crucial.
Just as a quick follow-up to that, it struck me that the very existence of that, quote, particular social group, unquote, category is itself basically an invitation for activist judges. And whatever the Attorney General does that would affect the immigration judges and the Board of Immigration Appeals, if it ends up going to the federal courts, then the judges just make up anything they want, which is what they've been doing with this particular social group. I mean, pretty much anybody can be defined as a particular social group. So my point here is it worth simply excising that from the 1980 Refugee Act? Because even though it's in the Refugee Convention, it was also put into our law. And there have been proposals abroad to simply eliminate that as a grounds for asylum.
Right, but I don't think it should be the Attorney General who makes a decision like that. I think Congress needs to act. For example, not too many years ago, the big dispute was whether coercive family planning in China was a ground for asylum or not. Congress got involved. They say, yeah, we don't want that. That's a ground for asylum. For some reason, they called it political opinion, but, you know, they changed the statute, and that's definitive, and that's problem answered. If the Attorney General changes it, then there's all the circuits that'll do their own thing with that. It could go on forever. Congress really needs to do some of these things.
Okay, any questions? Yeah, up here in the front. Yeah, wait for the mic, please.
I'm Peggy Ochowski. I'm the congressional correspondent for the Hispanic Outlook and cover immigration and higher ed. And I wanted you to elaborate a little bit more about particular privileges or considerations of UAMs, of the unaccompanied minors, and particularly the minor part. So, and I just want to make a point that with educational institutions, one is considered a dependent up to almost 26 years old, as with insurance. But if that minor has a child, they are no longer considered a dependent. And so it's almost impossible for a child to have a child and still be considered a minor. However, I think among the UAMs, there's a considerable proportion of these minors under 18 years old that indeed do have children. So I'm just curious about that whole concept of a minor.
Not sure.
It is an interesting thing. You know, when we hear about unaccompanied alien minors, we generally, you know, think of 6-year-old children. But the question becomes, if you're a 6-year-old, how did you get here from Guatemala if you're unaccompanied? And unfortunately, in a lot of these cases, the parents are complicit. You know, I'm a father. I love my son. I would never put my son in the hands of a person whose main stock in trade is moving heroin over the United States border. And we've actually seen ICE take action against parents who have paid smugglers to bring their kids to the United States. I think that's a crucial issue. The other thing is that, you know, most of the UAMs, most of the unaccompanied alien minors are minors in name. They're, you know, under the age of 18. But most of them are, you know, 17 years old. I can remember being a trial attorney in Baltimore, where Judge Burman and I both served as trial attorneys. And I would get 17-year-olds who were arrested at the orchards. They would pick apples. They were migrant workers. And as soon as they were apprehended, they would file for special immigrant juvenile status, which Judge Burman alluded to earlier. So, you know, it is sort of a misnomer in this instance. I've seen plenty of cases involving younger kids, generally with parents, but the number of cases in which there is, you know, a very young child of tender years who makes it to the United States independently, those are few and far between and very rare. There's normally a parent in the United States who has paid the smuggler to bring the child here. Let's bring the parent forward, and the parent can make the claim on behalf of the child.
Where the parent is under.
It's very difficult for me as a lawyer to argue argue what age emancipation should be. But, you know, it's important to keep in mind that most of these people are, you know, most of what we call minors are individuals who have made their way to the United States and who are generally just on the cusp of adulthood.
And I might also point out that minors are actually handled very solicitously by the law and by the regulations. Unaccompanied minors are not even prosecuted, if you want to use that word, by Department of Homeland Security. They're under HHS.
Right.
So, I mean, and the Wilberforce Act is very lenient. In fact, you can be an unaccompanied minor even if you have relatives here.
Let me point out here, just quickly on this issue, where a change of policy is very important. And if you want to understand this issue, all you need to do is read a federal district court decision issued, I think, 2 years ago by Judge Andrew Hainan, federal district court judge in Brownsville, Texas. And he issued a decision in a case in which a human smuggler, a woman who had been caught before for smuggling, was caught at the border with a young girl. I think the girl was like 11 or 12, very young. The smuggler was convicted of a felony, but the judge castigated the administration. Why? Because what did they do when this smuggler was caught at the border? They took the child delivered her to her illegal parent in Virginia. The illegal parent had paid a Mexican drug cartel to smuggle her daughter in the United States. In other words, they had, this illegal alien parent in Virginia had paid a drug cartel to smuggle her young daughter across the United States. And what Andrew Hainan, the judge, said was that he pointed out all the dangers of this, all the people who'd been killed by the cartels, young women who'd been raped and otherwise assaulted. And what did the government do? They delivered the child to her parent in Virginia. Now, I certainly agree that this unaccompanied minor, although they were accompanied by a human smuggler, should be reunited with her parent. But as the judge pointed out, rather than removing the child and the parent from the United States, they did absolutely nothing about it. Yeah, they prosecuted the smuggler, but they simply delivered the child. So what did the judge say? He said the U.S. government was completing this criminal conspiracy and encouraging more parents who are illegally in the United States to pay these drug cartels. They are the ones that provide the personnel who do this work. They were completing this criminal conspiracy and encouraging more parents to engage in this kind of extremely risky behavior. And what should have happened in that case, and what should be the policy of the United States government, is that, yeah, the child is reunited with their parent who's illegally in the United States, but then they are both removed from the United States and sent back to their home countries.
Yes, sir, your question in the back?
Thank you, Irv
Could you
Chapman.
identify yourself?
Yeah, Irv Chapman from Bloomberg Radio. Judge Burman, for people who don't follow closely what you do for a living, how often does somebody come before you, first of all, who you would classify, to use a colloquialism we've heard, as a bad hombre? And what do you do if somebody comes and says, my life is threatened by MS-13 or by the Taliban? My whole family is under threat. What do you do about it?
I'm not sure that bad
What are your
hombre is defined in the
desideratum?
statute, but, well, it depends what they're applying for. Deferral of removal, Saddam Hussein could have qualified for that if he could show that he'd be tortured if he returned to Iraq. There's no bad hombre exclusion for that. Most other things, a bad hombre, I assume, is someone who's committed crimes, serious crimes would make you ineligible for asylum, withholding of removal. So really, somebody like that could only apply for deferral of removal under the Convention Against Torture. But they have a right to do it.
Let me give you an example of what I saw in my docket for a number of years, and then I just stopped seeing. I was a judge in York, Pennsylvania. I was at a detained court. And I would often have dockets that would have 40% of my morning docket of 20 people would have drunk driving convictions or would have been arrested for domestic violence. And, you know, in most of these drunk driving cases, we weren't talking about a person blowing a .08. The highest that I can remember anyone ever blowing was a .32. And how in the world that individual was able to be alive, and that fellow actually admitted to me that he'd drunk a case of beer, his wife called, needed to be picked up at 10 o'clock in the morning, and he went and got her. But then those cases disappeared from my docket. They just weren't being picked up. They weren't priorities under the priority memos that went out in 2011 and 2014. It's very difficult for me. I'm a private citizen now, but it was very difficult for me as a judge to not look at those cases and not look at a person blowing more than a .15, more than a .20. And not say that that was a person who, merited bond, and so I would generally deny them. The vast majority of those individuals had no relief in the United States, and once they were caught, they would go home. And they would generally just ask for an order of removal, and I would remove them just then. The immigration laws of the United States don't define bad hombres, as Larry said. Quite frankly, if you enter the United States illegally, you are removable from the United States. And by illegally, I mean without a visa or without permission. If you come on a visa and you overstay, you are removable from the United States. As a judge, it's not up to me to decide whether that's the right thing to do or not the right thing to do. But the one thing that I will tell you is that if you allow individuals who enter the United States illegally to remain in the United States illegally, unmolested, as former ICE Director John Sandwig had indicated was likely to happen to individuals who simply entered the United States illegally, you're going to get more of them. Your docket's going to swell. This really is what we're talking about today. Why is the backlog so high? Because we weren't actually enforcing the immigration laws against people. We created perverse incentives for people to smuggle their children to the United States. We created perverse incentives for individuals to enter the United States illegally. The smuggling rate, the smuggling fee went way down because people could just simply come across the border and claim credible fear. I mean, this was a problem for the smuggling gangs. They didn't have anybody to smuggle because, quite frankly, you didn't need a smuggler. I mean, these are the perverse incentives that regrettably have been in place. You pull drunk drivers off the streets, you pull individuals who have committed domestic violence out of the jails, and you put them into immigration court. If they're eligible for relief, I as a judge am going to grant you relief. But if you're not eligible for relief, then Congress has said you should be removed.
Well, what about the other half of the question about fear of MS-13 or the Taliban? They're after me, they're after my family.
Absolutely. And I mean, it was very easy. I mean, you ask a question whether you have any fear of being returned to Colombia, whether you have any fear of being returned to Guatemala. It's incumbent upon me as an immigration judge to ask those questions. And let me make one other thing very clear. It's incumbent upon every employee of the United States government to enforce the Torture Convention. From the President of the United States to the guy that put somebody on the airplane. That is an obligation that exists. And generally, individuals were given the opportunity, I don't even say generally, always, individuals were given an application for asylum, withholding removal, and protection under Article 3 of the Convention Against Torture called 589, if they asked for one or if they advanced a fear, and I would hear their case. So, yeah, I mean, there are protections in place. It's not like we just grab people off the street and put them on a plane. That's what Larry Burman gets paid to do, to make sure that there are individuals, that the protections that are in American law are in fact enforced.
I had a quick question for either of the current or former judges. There's an old Soviet joke I remember I used to hear when I was a student in the Soviet Union, was that the factory workers would say, well, yeah, we pretend to work and they pretend to pay us. Well, is there a certain element of that in the immigration judge, for immigration judges, where, you're sort of going through kind of the motions, a sort of kabuki law enforcement, where the law isn't being enforced and then it ends up in your lap? And does that affect morale in the way that we've seen, for instance, in ICE and elsewhere, that affects morale?
Well, I think that happens, especially judges that have been on the bench for a long time and saw how it used to be, and then you're ready for a hearing and the government just administratively closes or terminates the case for no particular reason. Doesn't save any time because you were prepared for the case and you set the time aside on your docket. Yeah, that could get to people. I mean, it lowers morale. A lot of what I've been talking about is lowered morale. Judges being punished for trying to be efficient. They're punished for trying to move cases. They're never punished for continuing. They're never punished for granting relief that maybe shouldn't be granted. That's not good for morale. And nobody really likes that. Nobody likes to have a job where they're not really doing what they're supposed to be doing.
Well, no, go ahead. No, we can take a couple more, I think. Yes, sir, and then you over there. Yeah, right here, it's the mic.
Okay, thanks. Let's see, my question has to do with the U visa. I don't know if anybody's familiar with that or not.
Talk into the mic, yeah.
My question has to do with the U visa, is also known as the crime victim visa. My concern here, and this is both a statement and a question, my concern is that the number of U visas, the total backlog, including family derivatives, has risen from 13,645 at the end of fiscal 2010 to the current backlog reported by CIS to be 168,000. We estimate that it'll be 250,000 by January 2019. In view of this, currently it appears, and this is coming from other people, it appears that the 10,000 yearly cap, which is supposed to be mandated by Congress, it appears that the current or previous administration that is failed to abide by the congressional cap because they're giving immigrants that are applying for U visas green cards and deferred status. So I guess my question is, at some point, this trajectory is going to completely swamp the entire immigration system if this continues. At what point does the president or Congress step in and decide to implement the law so that there's a 10,000 cap per year, which means that there would be an astronomical, we're talking hundreds of thousands of cases, and how would this impact on our immigration system?
I don't know if there's a court angle to that.
Well, we don't adjudicate the U visas, which is actually part of the problem, because if we did, we could adjudicate them. And what happens is the alien admits that he's removable, and then the attorney says, but he's applying for a U visa. I want a continuance because it takes forever to get this thing approved or disapproved by DHS. At the moment, we have to continue those cases because if we don't, we're cutting off a line of possible relief. And but once again, it's perverse incentives that Art was talking about. There's no reason not to file these things, even though most of them are never going to be granted, because it gums up the system. And the more the system gets gummed up, the more people are going to file. That's what's happened with asylum, too. If everybody applies for asylum and they can't be adjudicated right away, then they get to stay. And they get to have, they get a work authorization. They might as well be citizens, except it's.
Are most of these individuals that are filing for appeals, are they being accompanied with free legal counsel?
Yeah,
It's
sorry.
being
Oh,
paid
sir,
for?
you can't talk without the mic. And we need to wrap up, so let's take two more questions, yours and then yours, and we'll have quick
I can
questions.
answer that after the.
My name is Brigida Mulligan, and I'm from Rockville, Maryland. And you know, there's been lots of cases that have been happening in our city. I am a legal immigrant, and I'm very concerned and cannot understand why an illegal alien is here and why the laws haven't been enforced. But you all have done a fantastic presentation to educate me on why we have the problem that we have. And it's appalling to think it takes so much to get an illegal out of our community. And no wonder we have the big numbers. What I'm hearing in the press is that these people have rights and they're not illegal, and they don't even want to use the word illegal. In our community, the legislators are saying it's undocumented. We don't have anybody illegal. I would like to have everyone know what illegal is, and I got a little education from you all. My question is, have you all followed the Rockville issues? I understand that there were 2 students who were given a scholarship and they were actually deported. So my thought was, oh my gosh, how did they deport these 2 when I'm hearing this process of how long it takes to get somebody out of the country when they're illegal?
Those 2 students actually already had orders of removal against them, which they had not appealed and had become final. So at that point, DHS can just pick them up.
And an important point on that is, you know, we talk about final orders of removal, but in my court, which was detained, I only issued one in absentia order of removal because the guy refused to come out of his jail cell and show up, and I didn't have a choice. But in, you know.
We'll explain why, because you were in a jail.
Right, I was in a jail. It was a detained court, I was in a jail, he refused to come down the hallway, I issued an order of removal, he never appealed it. But when I would be a trial attorney in a non-detained court, and I'm sure that Judge Burman will verify this, a significant percentage of individuals just never show up for court. And they're ordered removed in absentia. And then when the day comes that the government goes to enforce the order against them, they file a motion to reopen saying, oh, I never got notice of the hearing, or ineffective assistance of counsel and I shouldn't have been ordered removed, which again is one of those 23% of, you know, cases, new cases, that the courts are hearing. that slow up the system even more, so.
So let's take one last question. Sure, yeah, your mic's right there. Short question, and we'll have some short answers.
Back in 2008, the executive office that makes the rules for the immigration courts added a rule which is very similar to the Rule 11 in the district courts, which requires a attorney who ghosts material submitted by a pro se participant in the courts, immigrant, that attorney make an appearance, that is to say, file an appearance notice. Now,
We need a quick question.
the
Sean.
Western,
We
the
literally have
Western
to pull the
District
plug here.
just made a preliminary injunction so that this rule is not the rule as of today. My question is, during the period between 2008 and when this preliminary injunction was issued, was the rule enforced that you cannot ghost a submission to an immigration court without making an appearance, saying who you are?
But how would the judge know it's being ghosted?
And that really is the biggest issue, is that the court only knows what the court is told. And for that reason, if there is, we have a big problem with notarios, people who are notary publics in the United States who hold themselves out as attorneys and, end up filing frivolous asylum applications, for example, or frivolous immediate relative petitions. And that's a problem, yeah. It is one that we have to crack down on.
Okay, thank you, everybody. Thanks for the panelists, for the audience. All of our work is online at cis.org, including Art's paper, and the video of this will be posted as well. So hope to see you next time. Thank you.